Hello everyone, I am back with another video on Here's the Tea with Dremma C. Today we're going to be discussing domestic violence cases. October is domestic violence month. I am just leaving court after being in court for the last 3 hours, assisting petitioners with return hearings. There are oftentimes a lot of petitioners that appear in court without representation, and they're very unfamiliar with the law, the requirements, and the factors that must be met in order for the court to grant an injunction. And so I'm just going to provide you with a little information, a little overview of what the court process is like. So anytime that you fill out a petition for domestic violence, you want to make sure that you're very, very detailed as to what has taken place and why you feel that you are in fear. If you're alleging that you have been a victim of domestic violence and have been physically assaulted or beaten, you want to make sure that you're providing details to the court so that the court has a better understanding of what you're going through and why you are in fear and why you need the injunction. If you are unrepresented for your hearing, unfortunately, the judge cannot give you any type of legal advice. And so I know oftentimes, whether it's the petitioner or the respondent, there are a lot of questions that you may have. Unfortunately, some of those questions the judge cannot answer because it is considered legal advice. So I always recommend that you seek legal counsel. There are plenty of organizations that will provide free legal assistance to victims of domestic violence. Reach out to someone, get information, and then also too, a lot of times the judge will explain the process, so make sure that you're listening to the information that the judge is providing you, because a lot of times they'll answer the questions that you may have. And so you want to go in there and make sure that you're paying attention and that you're listening to the information that the judge is providing, because ultimately that may answer the question that you may have. But I highly recommend that if you have any evidence that you want to present in your case, that you have that evidence handy and ready. And so when I say that, a lot of times individuals may have evidence on their phone, or there may be evidence that is on their laptops. If you want the court to take that evidence and use that evidence and take it into custody, that would mean that you would have to turn in your phone or your laptop. You're not going to get that back. So if you have videos, put them on a thumb drive, a CD, a DVD. If you have pictures, if you have text messages, print off hard copies so that you can give that to the court, and also a copy to the other party so that they can review them prior to the hearing. And it's very important that you are very detailed. You present any evidence that you may potentially have, and then also any witnesses that you may have. So you want to make sure that you're giving the court a full view and understanding of what you're experiencing and what you're going through. A lot of times the injunctions are denied because there's not enough information in the petition for the court to make a determination as to whether a temporary should be granted. This has been another episode of Here's the Tea with Dremma C. Until next time.